It's time for part 2 of our review of A Grant of Rights.
Conference realignment is always in the news, so we're back on the big mountain to break it down for you.
Hey, it's great to have you here on the mountain. Hopefully you saw episode 1 of this 2-part series. If you didn't, I am going to put that link up in the corner. I suggest you probably go back and check that out real quick before you watch this one. So I want to make sure we start off with that. But if you're new to the mountain, I'm JY. This is my good friend Steve. We did a 2-part series on the Grant of Rights and reviewing the article from Mark Wilhelm that he had done back in 2017, and it was put into the Harvard Law Review. Our first part of this, we kind of went through the main reasons for realignment at the time. In his view, he kind of laid that out. He talked about current solutions to realignment. We dove into that. This episode is going to be more about challenging the Grant of Rights, or possibly being able to challenge the Grant of Rights. That's going to be the main focus of this episode. The second part, then I'll give you his conclusion, what he thinks a Grant of Right is, what it was for, how it was being used, and the longevity maybe of the Grant of Rights document. So, we're going to jump right in. He gives us 4 areas where he thinks a Grant of Rights could have some legal issues. Now, we're going to focus some of our comments around the ACC. Obviously, we're doing this episode right now because of the ongoings of the ACC's lawsuit with FSU and vice versa. So you will hear us put some ACC opinions into this. But his review was just on the Grant of Rights document in general. It wasn't about one conference or another. It's just reviewing the document.
And to kind of to review, we said that basically the Big 12 lawyers were the ones that originally came up with this, and it's been kind of farmed out to the other conferences.
Yes, my understanding is the ACC used not a copy and paste exactly, but a lot of the verbiage from the Big 12's originally from the Big 12's Grant of Rights into theirs. So let's talk about irrevocability. And this is going to be, I mentioned that we're going to get a little heavy on some of this in the first episode. This is the heaviest piece. So I'm going to knock you with the heaviest part of this whole series right now. And I'll try to make sure I get through this and you have a good understanding of what he is saying here, because it does get, it's a little back and forth. Got to really pay attention. So JY is going to slow down here and make sure I talk very clearly. But his opinion is that after reviewing a Grant of Rights, that there may be some issues with assignments on face value. Remember that irrevocability of these is a huge importance for a conference to stop or at least slow realignment. The Grant of Rights are understood to be assignments and only irrevocable if made for good consideration or if a writing supports its irrevocability. He admits that making an argument based on a lack of consideration can be difficult. Two differences here. We just mentioned the Big 12 and the ACC. The Big 12's Grant of Rights does place consideration for that grant of the rights. The ACC does not, and it must be made in writing. This is much more challenging for a school than the consideration requirement. However, this requirement assumes the grant is an assignment and not a bilateral contract. As an assignment, there's a timing issue. The ACC Grant of Rights was executed after the broadcast agreement. This is evidenced by the fact that the ESPN agreement is actually referenced in the ACC Grant of Rights. We talked about that in episode 1. I do want to give a shout out to one of our commenters, Jonathan D., who correctly pointed out that the ACC amended lawsuit in 2013-2016, that the ACC clearly did state its purpose is to serve the ACC media rights agreements. That's the purpose of the Grant of Rights. This is where things get a little tricky, but is very, very important. A school would need to point out the fact that the broadcast agreements are contingent upon the assignment. For ACC versus FSU, this means that ESPN entered into an agreement if and only if the ACC members bound their broadcast rights for a given time. This binding of rights can be called an assignment, but at the heart of the agreement is a mutual exchange, aka a bilateral contract. If a school can effectively argue that the assignment is a bilateral contract masquerading as an assignment, then they can turn to the significance of consideration. This is an argument that a school can actually win. Why? This is because the grant of rights is between the school and the conference. The consideration from the conference to the school are the grant broadcast rights. Thus, the consideration given here is from the media agreement, not from the conference. The only reason to sign a grant of rights is to secure a member's claim to their share of the broadcast revenue. No new consideration was given for this, and because of that, the grant of rights contract fails to be enforceable. Lastly, he talks about injustice. Avoiding injustice does not lend much support to the irrevocability of the grant of rights. The grant of rights isn't really a protection for the conference. It's an insurance policy for the network. If a conference cannot provide the teams to play the games, the network is harmed, not the conference. This means that the conference will have a very difficult time showing an injustice. The second piece that he talks about, where maybe some legal challenges can be discussed, this is one that we've talked about on a previous episode, that of liquidated damages. As a preliminary matter here, he says he's unsure that the penalties associated with the grant of rights can be characterized as liquidated damages. There was a Trustees of Boston College case that basically had the judge completely punt on this matter. Didn't address it. He punted it. If they are deemed to be a measure of liquidated damages, the enforceability is still a question. This uncertainty should be concerning to any school attempting to leave a conference, as there is incomplete information here in order to make a decision. So it's a bit of a risk reward. You've got to understand, how much risk are you willing to take not knowing the answer to that question. The third item, lack of specific performance. If a school chooses to revoke a grant of rights, it seems inappropriate for a conference then to request a breach of contract remedy. Conferences will have a difficult time demonstrating that monetary damages are inadequate. If you remember, the ACC has brought a breach of contract remedy in their amended filing. The last thing he talks about is just generally vague. And I hear this a lot for those that have seen the grant of rights. They say, these things are just vague. And he talks about this. He says the grant of rights is only as enforceable as it is challenged. It is basically a triple dog dare. Thus the reason people call it ironclad. Like, I'm going to triple dog dare you to do anything with this sucker. And up until now, Steve, nobody has. And again, the reason why it's considered ironclad, nobody has tried to pierce it yet. The entire text of a grant of rights is only a few pages long, and none have termination provisions or any mention of liquidated damages. Basically, what they do not say might be just as important or more important than what they actually do say. To be clear, a grant of rights did not need to be made. However, the majority of the members wanted it to be made. A simple cost-benefit analysis likely leads schools to comply with the grant of rights. His conclusion then, the grant of rights is a legal band-aid on a business issue and should not be viewed as a stopgap. It should be viewed as a stopgap. To assume it is a long-term solution to the realignment issue is a complete misunderstanding of the motivating factors for realignment. Those motivating factors we talked about in episode 1. So again, they were money, on-field performance, university exposure, and the college football playoffs. I think he summarizes this here in the end perfectly. The fact that they didn't need to be made, but at the time they wanted them to be made, they being the members. What they don't say is just as important as what they do say. Yeah, they're ironclad because up until now, they've never been challenged. So, heck, if nothing's ever challenged, you can say that baby's as good as gold because it's kept everybody together.
The Titanic was unsinkable until it hit the iceberg.
There you have it. Perfect example of it right there, right? And he also, his conclusion is a grant of rights was never going to solve in the long term realignment. He says it's a Band-Aid. They've used this Band-Aid now for a decade plus, and things beginning to break. The iceberg has been struck. So that's kind of the end of it, Steve. But we're going to go to our thoughts and analysis. So what are you thinking?
Yeah. So first of all, I want to kind of repeat what you said, and just thank you to our viewers, our commenters. I think we had a couple people suggest this article.
Yes.
Reading through this, it brings me back to my MBA days of looking for a scholarly source. I mean, all due respect to Dennis Dodd and
right.
Some of the other articles we covered. This is definitely more of a serious legal article, legal opinion,
right.
which I think is great. All of it is part of the conversation.
Yes.
And I think this is just an important piece.
Yes.
Basically, and a lot of what he's saying has, obviously, he's a lot smarter than me. He knows the law. He's a lawyer, and he knows the law a lot better than I do.
Right.
But it really goes along with the line of thinking that I've had. There's been so many people who have said the grant of rights is ironclad, and the evidence to that is because no one has challenged it yet. Mm-hmm. Well, the corollary to that is also true then. When someone challenges it, it's no longer ironclad.
Sure.
And I think that's kind of where he's going.
Yeah.
To me, the whole thing, obviously the members of the ACC, including Florida State back then, North Carolina, Clemson, all the members, they wanted to do this to themselves. They created this bluff game.
Yep.
They wanted to make it so powerful and so scary, basically, that nobody would leave, and it's a big bluff game. Who's the one who's going to leave first and turn around and run away first, and the rest of us are going to try and shoot you in the back, basically. Right. So they created this bluff game, and there's no way. At the end of the day, if Florida State wants to leave the ACC, they're gonna leave the ACC.
Right.
Anyone who thinks that there's going to be a remedy that keeps them in the conference, I think is maybe just, I hate to say naive, but I just don't see how that's possible. At this point, it's a case of what are the damages, and he makes a lot of arguments that there are not necessarily damages to the conference, but more to their media partner.
Yeah.
So
right.
In this case, I really see, and it's something we've touched on a few times, I see this first part of the challenge to the grant of rights, where Florida State takes action, as coming down to a battle, maybe a proxy battle, but a battle between the state of Florida and back to ESPN and Disney, which is what we've talked about and we've touched on.
Yeah.
Because that's what it comes down to. ESPN, some could say, took advantage of a situation where the entire ACC was willing to hold themselves hostage and deliver themselves at a cheap price to ESPN because they thought that was the way that was going to ensure their long-term survival as a conference.
Yep.
And really, it's worked for a while. Okay. It's worked for a long time. No one has successfully challenged it. No one's really tried to challenge it. So for me, where I'm at, reading that article and going through everything we've talked about, I really feel like at this point it's a matter of time. And I'm kind of repeating myself from part one, but a big part of this is the conference and now ESPN limiting their damages.
Yes. Can
we extract some money? Can we get some money out of them? Which kind of puts everything in a unique situation because, if let's say Florida State, Clemson, some of these other schools, they want to leave the ACC and go to the SEC potentially. We've focused on the prospect of Florida State going to the Big Ten because that's one of our conferences we focus on. But some of these schools may want to leave and go to the SEC. Well, who is the SEC's media partner that they're locked in with? That's ESPN and Disney. So that really creates a strange situation where these schools might have to fight, go to court and fight to basically just hop from one bed to the other that both has ESPN's name over the headboard.
Yes.
So, very interesting. I think, to me, this article really puts a pin in the entire notion that the grant of rights is ironclad, and again, just reinforces that notion that it's inevitable. If Florida State wants to leave, they're going to leave. There will likely be a settlement, and it'll come down to how much money can the ACC and ESPN extract out of Florida State and anyone else that wants to leave.
Mm-hmm. Yeah, I agree. And, I would just say, this is kind of our third episode on reviewing different articles, different opinions. So the first one we did was the Dennis Dodd article, and that was really one that he did it back in, I think it was May of 23, and it was, this thing is ironclad.
Yeah.
And we read the article, we gave our opinions on that. And that's when we got this article sent to us and goes, hey, you guys need to read this because that's not what this one's saying. Right. And this is just discussions that we're having. You've said that before. We did the other lawyer comments on a few things. That was an episode. So, again, this is really the kind of the third review of different people's thoughts, two of them being lawyers, one of them being a sports reporter, I guess you could say.
He tried to kind of collate a bunch of lawyers' opinions into one article. But,
Correct. Yeah. So, and if there's more stuff like this, we absolutely would love to do it. I appreciated this just because it got into the details. We're more detail oriented here. We like the why behind the answers, if you will. And not that any of this that he gave us is an ironclad way to pierce the grant of rights. None of them are, and he's clear at that. He's like, this could be a reason, this could be a reason, but all of these have their own associated risks to them, and it's up to a school to determine what's their risk tolerance. And clearly, to me at this point, the straw that broke the camel's back was the CFP and the snub of Florida State in their minds not getting in. At that point, they said they already knew they were leaving. I think we all know that. ACC or the FSU was going to leave the ACC, but I think that the reason this got pushed when it did is because they didn't make the college football playoff. That was it. The trustees had enough. We're moving now. And that's where we're at. So it's not any one of these items. It's just a combination over years of this. This didn't happen over a month. This has been ongoing now for a while.
Agree. I do have one other point.
Yeah.
So we've talked about a settlement, and when we looked at the pack, we said, both sides have to have a reason to come to the settlement table. Mm-hmm. It's not usually a good reason, a positive reason. It's usually risk. Like, both sides have to have risk that scares them into coming to a settlement. I really, really, really think that the ACC has a massive amount of risk. Basically, the risk of its very existence. Mm-hmm. If they don't settle this, and maybe even if they do settle it, but if they don't settle it, and the entire grant of rights gets thrown out in court, they run the risk of everybody can just walk away. They go from being unbreakable, unsinkable one moment to being just basically a loose conglomeration of schools. Yep. In the next moment, there is so much risk there. So you've made the mention that ACC is going to fight, and I agree with you. They are going to fight, but I think at a certain point they're going to realize there's just so much risk to their existence as a conference. It's going to push them to the bargaining table, and I think for Florida State, they just want to get out. Like, they're just trying to get out as soon as possible. That'll be their motivation to get to the settlement table. So just wanted to throw that in.
Yep. Great point. Hey, want to make sure you guys are aware we are going to be starting a new series. We just did an introduction video to that last week, but the series is going to start here this week. It's going to be College Football 2030, and we're going to have about 6 episodes where we lay out what we think college football is going to be like here by the end of this decade. That might be of interest to you. If it is, go back and check out that intro video. The first real episode will be coming out this Thursday. And with that, we hope you appreciate what we're doing here. Give us a like, give us a subscribe, give us some comments. Anybody has another article that you find on this, we would love to jump on that one as well.
Absolutely.
So we appreciate your guys' comments. Got some great viewers out there. And we'll see you next time on the Big Mountain.
Is Florida State the iceberg that's going to sink the unsinkable?